The government regulation in lieu of law or Perpu on job creation has made changes to the company law in Indonesia, particularly concerning the minimum authorized capital requirement. One of the major changes outlined in Article 109 of the job creation Perpu is the removal of the previously mandatory authorized capital requirement of 50 million rupiahs. Now, the amount of the authorized capital is determined based on the decision of the company's founders. Government Regulation number 8 of 2021 provides further guidelines on the capital requirements for limited liability companies, or PT. According to Article 4, at least 25% of the authorized capital of the PT must be issued and fully paid up. This payment must be proven with a valid proof of deposit, which must be submitted electronically to the Minister of Law and Human Rights within 60 days from the date of the company's establishment deed. Article 5 of the same regulation specifies that PTs engaging in certain business activities must meet the minimum authorized capital requirements as determined by the relevant regulations. For instance, insurance companies must have a minimum paid-up capital of 1 trillion rupiahs. This indicates that there are exceptions and specific requirements for certain types of businesses which are further regulated by sectoral laws and regulations. For foreign investment companies, or PTPMA, the capital and investment requirements differ from those for domestic PTs. According to Article 12, Paragraph 2 of BKPM Regulation number 4 of 2021, the minimum investment value for PTPMA is more than 10 billion rupiahs excluding land and buildings for each business field according to the 5-digit Indonesian Business Classification or KBLI per project location. This rule ensures that PTPMAs operate only in the large business category, protecting smaller domestic companies from competition with foreign companies. However, there are exceptions for specific business sectors such as technology-based startups in special economic zones in Indonesia, where the investment value can be less than 10 billion rupiahs. It is important to note that the investment value differs from capital. Regarding capital, Article 12, Paragraphs 6 and 7 stipulate that the minimum issued/paid-up capital for PTPMA is 10 billion rupiahs, again, unless otherwise specified by other regulations. In Indonesia, PTPMA does not mean that the majority of the shares are owned by foreign entities. If a PT has any foreign ownership, even just one share, it is categorized as a PTPMA. This means that if a foreign investor wants to purchase shares in a domestic PT, the PT must be reclassified as a PTPMA. If its issued/paid-up capital was previously less than 10 billion rupiahs, it must be increased to at least 10 billion rupiahs to proceed with the share purchase by the foreign investor.